Okay. Mm, yeah. Okay, there is our information about us. Okay. Okay. So what we really hope tonight is that you get a better understanding of what a special needs trust is and how it can help provide some peace of mind for families. Understand the importance of your estate planning and learn the responsibilities of a trustee for a special needs trust. Okay, so Plan, who is Plan of Mass in Rhode Island? We are a nonprofit 501(c)(3) serving as professional trustee for individuals of any age with any disabilities in Mass and Rhode Island. And we were founded by parents of children with disabilities who were worried about what was going to happen to them after they were no longer here. We've been in business for over 50 years, and we are the oldest and largest special needs pool trust in New England. So Plan actually started in the 1960s. It was a group of parents who got together. They worried about what was going to happen when they weren't here, who was going to advocate for their loved ones, and who was going to make sure that their needs were met. And we became incorporated in 1971. So again, our Plan's mission is to educate and advocate for people with disabilities by letting them know that special needs trusts are an option for them. We are preserving assets, protect access to public benefits, and to live well. Plan is the only special needs trustee that is staffed with licensed social workers, of which Kathy is one. We have a team of 10 licensed social workers who go out to visit all the beneficiaries to want to make sure they're living well, to make sure that they are getting all the benefits they're entitled to. And the social workers will work on what we call a care plan with the beneficiaries to address needs that they have now and needs that may come up in the future. So what is a special needs trust? If we think about, I want to build myself a brand new house, right? So what do I need to do? I need to go to an architect and get a set of house plans. And then I need to create a budget. I need to, consider some inflationary charges in there. And then I'm going to look at my toolbox. And so a special needs trust would be one of those things in the toolbox. It's a way to be able to set aside funds to ensure that your loved one's needs will be met, but never interrupt their public benefits. So these special needs trusts fall under, here we go again, I always fumble this over, Omnibus Budget Reconciliation Act from 1993. That's where the federal regulations allow for the use of special needs trusts. And so what does it do? It helps protect the beneficiaries' public benefits. It's a way to make sure that there's some assets set aside that will supplement their needs. It helps the families have peace of mind knowing that they've planned for the future of their loved one. And it provides the beneficiary with resources, not only to supplement their needs, but really look at the quality of their life. Okay, so why would someone need a special needs trust? As Kathy just said, peace of mind. Knowing that you have something in place for your loved one is really, really important and comforting. And quality of life, again, we feel that Plan with our licensed social workers, the care plan that is devised, then people are able to use the trust for so many things to improve their quality of life. We do things like music therapy, all kinds of really great things that include. Right. So one of the reasons that you really want to look at something like this in March of 2021, there was an article written that said that the average person with a disability requires approximately $18,000 more a year to live the same lifestyle you and I would. And depending on the needs, that dollar amount could even go up.
Improves family relationships. We strongly feel that plan as trustee can make those hard decisions, but that family members should be there to advocate for each other.
Mhm.
And future needs, assuring that they'll be met. This population sometimes is taken advantage of, and we have a team of licensed people here that a trust officer, and every single withdrawal for a beneficiary is met and reviewed, and you can be sure that the distributions are for the sole benefit of the beneficiary.
Right, but protecting those public benefits is really important. So in the state of Massachusetts, in order to be on supplemental security income, and your Mass Health can't have more than $2,000 in assets. So that's really not enough money to live a quality lifestyle. So there's different types of public benefits. I'm sure many of you already know that, but having public benefits, we've run into families through the years where they've said, oh, I don't need that. I have plenty of money. And, there's a value to the public benefits. There's many programs out there that you can't get into unless you have Medicaid. And the benefits the value of them can really add up. So if we look over a 40-year period for somebody who's receiving their supplemental security income in Mass Health, that benefit can be worth up to $400,000. So it's really important to maintain those benefits and then have these funds that will, supplement them and not impact your benefits. There's lots of studies out there that show how much the cost is. So raising a child with special needs, there's been some studies out there from in November of 2020 that said, depending on the needs, how much needs they have, it could cost up to $85,000 a year to raise a child with special needs, between equipment, loss of work, co-payments, special therapies, all those kinds of things.
Okay. So what type of special needs trust does plan offer? The first is a first party or D4A. This is one trust document, one trustee, and one beneficiary, where the funds belong to the beneficiary. It protects eligibility for public benefits, and it is funded with the beneficiary's own money. There is a Medicaid payback for this. So Medicaid would have a lien for whatever was paid out to the beneficiary over their lifetime. There is a Medicaid payback for that.
So that means that, I may have gotten an unexpected inheritance, or I got a personal injury settlement. And I have to keep in mind that I have that $2,000 asset limit. So in order to maintain my benefits, I want to put that money into a special needs trust. So the first party trust means that it's my money. It's called a self-settled trust.
Mm-hmm. The second type is a third party standalone trust. This is one trust document, one trustee, and one beneficiary, but the funds are donated by a family member or friends.
So that would be that I have a family member. So Nancy's my family member. I'm worried about her future. So I can put funds into this third party trust that is used for her sole benefit to supplement her needs. The difference is at the end of her life, I've determined where the remaining funds are going to go. It was never her money, so Medicaid doesn't have any right to that money. I'll determine where it goes.
And then there's the pooled trust, D4C. So you are joining a master trust. It allows the funds to be preserved for the sole benefit of a person with a mental, developmental, or physical disability. And the trust document is already in place. It can be funded by either a first party or third party. And it is pooled for investments only because there's powers in numbers. But each beneficiary has their own sub-account within the pooled trust. And a couple of federal regulations require that the trustee of a special needs pooled trust must be a 501c3 nonprofit organization like Plan. And for individuals 65 and over that want to establish a special needs trust, They must be in a pooled trust. That is the only option.
And then there's one more option. That is through your estate planning, you can establish what we call a future funded trust. That means that you have done your estate planning and your life insurance, or even your will, or pension, retirement accounts. You can name the special needs trust for the benefit of your family member's name, so it's funded upon your death. So people worry, often with families with the third party trust, we talk to families on a regular basis that I can't retire. I can never retire. I need to keep making this money to support my family member. But you can, and you could use your life insurance, or you can use an inherited IRA, things like that, to establish the third party trust and still have your own funds and enjoy your own life. First party trusts, those are for unexpected inheritances or personal injury settlements, things like that. And you can have more than one trust. You can have first party, you can have a third party, doesn't matter. You can have multiple trusts.
Okay, now that you know more about special needs trust, how do you choose the right trustee? So you need to think about services that are needed now for your loved one and services they may need in the future. And being a trustee, like we have said, it's a full-time job. We have a large staff here that talks to all of the beneficiaries, caretakers, and looks at the withdrawals. And like we say, we feel that it's better for family members to be the advocate and not be the bad guy to make the decisions. Like if the beneficiary wanted to buy a Porsche and we don't think that that's the best use of their money, then we're probably not going to say that that's a good use of your money. So let us be the bad guy, and other family members can not have any strain on their relationships.
You think about money in any type of relationship. You don't have to have a special need, any relationship. When you put money in the middle of that mix, often it doesn't work out very well. And this way, if you have a separate trustee that's not a family member, then those family relations can stay intact. And then that family member could be the advocate, help advocate with the trustee. This is what I want, this is what I need, and this is why. And then they have that support system, and it helps. They spend holidays together and help maintain those relationships. You want to do this one?
Yeah, so again, a lot of this is repetitive, but removes the responsibility from a family member. We do all the investing, account taxes, fiduciary reporting. And again, the security, knowing that the trust withdrawals are for the sole benefit of the individual. It is definitely the case that people can be taken advantage of. So you can be sure that it will be only for the beneficiary. And again, we focus with the licensed social workers on living well and carrying out the beneficiary's wishes.
But the trustee also has a lot of responsibility, right? You have to do the investments, and then there's the annual accounting, and there's the taxes on the trust, and then there's K-1s or grantor letters issued. So the professional reporting of the funds is part of being a trustee, and it can be a full-time job, believe it or not. There's a lot of responsibility that has to be carried out, and knowing the public benefits and ensuring that those distributions aren't going to have a negative impact.
And again, these are some of the services: annual statements, weekly disbursements, grantor letters for the first party, K-1 for third party, filing of 1041. It is a full-time job, as Kathy had just said.
So here at Plan, we don't have, for the pool, we don't have a minimum. We do recommend that you put at least 10,000 in, but we don't have a minimum. And every beneficiary is assigned to work with a social worker. We call them service coordinators here, but you're assigned to work with a service coordinator throughout the life of the trust. And that service coordinator is going to work with the beneficiary and their support systems on how to utilize the funds, how to access the funds, but also checking in and making sure that you're in that the beneficiary is in a safe place, they're being well cared for, they're accessing the benefits they're entitled to, all those kinds of things. So collectively, it says 100 years on here. I think it's more like 250 years. I just aged myself, but that's okay. And they're well versed in benefits and the disability world, and the services that are available out there. So, and they become the primary contact, the liaison for the beneficiary with the trust. And they provide that guidance, and they also provide advocacy for folks. And it ends up being a really nice relationship. We go out to our beneficiaries because I firmly believe if we don't know who you are and where you are, how do we serve you, right? So we want to go out, we want to see you, we want to look at your living situation, your environment, all those things to make sure that you are being well cared for.
So now that if you've decided you'd like to move forward, what you can do is give us a call. We know that this is a very important decision. Decisions for your loved ones are never easy. But you can call, or there's no charge for calls. Call as many times as you want. And you can choose an attorney, a special needs attorney, one that is licensed in special needs and elder law. And if you don't have anybody that you know, we can give you a couple of names of people in your area. Then you would deposit the funds into the trust, and then our service coordinators would contact you and start meeting with you.
So attorneys are just like doctors. They have areas of specialty. So it's really important. I know that, you know, you can drive down the highway and see billboards or open up a newspaper and you'll see advertisements and they'll say, oh, I do trusts, I do this, I do that, I do that. But this is a very specialized area. So if I break my leg, I'm not going to go to my eye doctor and ask my eye doctor to set my bones. So lawyers are the same way. You really want to find somebody who specializes in this area. To join the pool, you don't have to have an attorney, but we strongly encourage you to get one because you're signing legal documents, and special needs trusts are irrevocable. And for people who do those future funded trusts, you still get to meet your service coordinator, and that's when you work on your life care plan. And that life care plan is going to tell us all about you, your family, the beneficiary, their providers, their interests, their needs, all of those things, plus what your goals are for the funds, what you would like to see happen with the funds that you have set aside. Oh, ABLE, this is everybody's favorite topic, achieving a better life experience. However, it doesn't have to be one or the other. So ABLE, currently, it's going up in 2026, I think. But currently, your disability has to have been determined prior to the age of 26. You can only put in whatever the gift tax rate is for the year, which is currently $17,000. The only exception to that rule is if the beneficiary themselves is working, they can put an additional approximately $13,000 in, and it can only be one ABLE account. Where with the special needs trust, there's no limit as to how much you put in. And the trust can be used for quality of life expenses as well. We do some fun things for folks. We've sent folks on trips. And your trust can fund your ABLE account annually. And you can have multiple special needs trusts. You can have first party, third party, future funded. You can have 2 third-party trusts. We have many folks like that. So ABLE is managed by MEFR and Fidelity, and there's a little teeny print in there that says that there's a Medicaid clawback, which means that Medicaid can come back if the beneficiary passes away from the date that the ABLE account was established, and then they can be paid back from there.
Okay. Thank you very much for your time. We know this is a lot of information, and it's it can be a involved process, But this is our information. Call as many times, reach out to us. We're here for you.
We have a great website as well. Folks can go on there and find lots of information on there as well. We don't charge folks for that. We know what a tough decision this is and how scary it is. So we appreciate that. So call as much as you want. That's fine.
Okay,
All
we're
right.
going to address the chat questions.
No question.
Gotcha. No question. Oh, question and answer. There's a couple on there.
Mhm.
Please confirm that there is no limit for what is included in the special needs trust.
Do you mean the dollar amount? So if it's the dollar amount, there is no limit as to how much. Yes, you can put as much as you want
Yes.
in a trust.
I am a former banker, so as you know, a lot of times in banking, we had a threshold for trusts. And this is a wonderful thing that plan has no minimums because we did have quite large minimums at the bank.
Mm.
Any other questions?
Alrighty. Oh, no. That's
No.
it. Alrighty. I'll just stop share.
All right.
If I do not
Oh.
have a lawyer to work with, who do you recommend? So typically we'll ask you where you live and we'll try to recommend at least 3 people that are pretty close to where you live.
Anybody else? All right, I don't want to hold up Frederick. So please feel free to always call us, email us. We're here for you. We're here to answer your questions and to support
Yeah.
you. Sorry? Okay,
Don't work out.
no, I'm not. It's just a stop share, right?
Mhm.
Okay,
Mm.
Nancy and Kathy, thank you very much. That was really a fantastic overview. A lot of great information there. I'm going to share my screen. I'm not going to be duplicative here, but a lot of things that you've gone over are spot on. And really the folks at Plan, their work is, my work as the attorney is front loaded, where Plan is ongoing through the administration of the trust, which is so important. Can you see my screen? Is that working?
I can't see your screen now.
All right.
So I can see it now. Perfect.
So I'm attorney Fred Hayes. I'm an estate planning and elder law attorney with Pfeiffer Pinkham. We are a full service business firm here in Quincy. I specialize in estate planning and elder law. I've been practicing this area for about a decade. As Nancy and Kathy said, it's so important to work with an attorney that specializes in this field. Very good observation that most attorneys will say they do wills and trusts, but you really want to work with someone that specializes in this field and practices solely in this and stays abreast of all the changes and updates. And I guess when we look at the question being, is a special needs or supplemental needs trust right for you? It's important to take a holistic approach to estate planning. That's always what we do. We meet with clients. We have our intake forms, our questionnaires. Really, it's my job as the estate planning attorney to be a fact finder, to ask the questions about your beneficiaries, about your needs, as we look at those future funded trusts. We get the phone calls for the first party special needs trusts. It's, as Nancy and Kathy explained, it's a settlement from a lawsuit. It's an unexpected inheritance where that asset receiver is receiving community benefits and they're concerned with being in jeopardy of losing those benefits by way of this windfall. So I'm not going to repeat too much of what Nancy and Kathy went over. They were spot on. But just from a legal perspective, what is a trust? A trust is the separation of legal and equitable title. And what does that mean? It sounds like some lawyer speak. Well, it's because it is. So legal title is the authority to control an asset, whose name is on the deed, whose name is on the bank account. And equitable title is who has the right to enjoy the benefit. So that is our beneficiary. So a lot of attorneys will refer to trusts as your safety deposit box, as the treasure chest, or a rule book. Really what it is a private contract that takes title to an asset And now that private contract, that rule book is determining how distributions are made, who is in control, and who is going to receive the benefit of the assets in trust. Very quickly, who makes up a trust? We've got three major roles: the donor, the settlor, the trust maker, all terms for the same person. That is the person creating the trust. And a lot of times that is the person or one of the people who are depositing assets into the trust for the benefit of our beneficiaries. The trustee, I made this in the largest type font. It is the most important role. The person who administers the trust, this is the overseer. These are the folks at plan that are dealing with the trust, dealing with the beneficiaries every day. Trustees have a lot of authority, a lot of control, but they only have the authority to do what the trust explicitly states. That's why the devil's in the details. It's also important what the terms of your trusts are. And our beneficiary, of course, the person receiving the benefit, beneficial interest of the trust, the person whose distributions are made for. Trust funding, Nancy and Kathy did a fantastic job describing this. So different ways to fund your trust, those standalone third-party supplemental needs trusts, first-party supplemental needs trusts especially, those are funded during the lifetime of the donors, whether that's the benefit recipient or mom or dad or some other friend. That is the process of taking the assets, going to the folks at plan, establishing the account in the name of the trust. Other ways to fund the trust, as Nancy and Kathy alluded to, a future funded trust. Those can be funded at death, either by way of an estate plan where your trust, your will, provides for assets to be funded upon your passing into a supplemental needs trust, which would be a separate standalone document. Another method I would not recommend is by way of a pour over will. So a big takeaway here, a very common misconception in the industry: if you denote a beneficiary in your will, if you create a will and you say that upon my passing, all of my assets go to the John Doe Supplemental Needs Trust for the benefit of my friend. If the trustee takes that will, walks it down to the bank where they know the person who drafted the will had an account, and they present the will to the bank teller is going to say, I'm sorry, even though you're named in the will, I see your ID, I see the death certificate for the account holder, I can't just give you the money in the account. How do I know that you're not a scam artist? How do I validate any of these documents? What's required at that point is the probate process. So the named personal representative in the will has to take that will down to the probate court, pay a $405 filing fee, wait 6 to 8 weeks, make a publication in a newspaper just to get the asset of the decedent into the supplemental needs trust where it belongs and where the decedent intended for it to go. So we work with our clients very hard for these future funded trusts to make sure that they can bypass the probate process and make sure that day number one, there is no delay in having the assets being applied for the benefit of their beneficiary, no additional legal costs, and making sure that assets are immediately available. So very, very important, if you're working with an attorney, always talk about trust funding. How is this asset going to be funded? Best practice, fund it now during your lifetime. Make sure there's a mechanism in your trust to fund it to your supplemental needs trust. Or, as Nancy and Kathy alluded to, make sure you've got proper beneficiary designations on your life insurance policies, IRAs, or other accounts. So that day number one, we do not need the probate court's involvement. Your trustee, successor trustee, can immediately gain access, authority, and control over your asset and immediately start applying them for the benefit of your beneficiary. Types of supplemental needs trusts. I won't spend much time on this. Nancy and Kathy did a fantastic job. First party, third party, it really depends on who has touched the assets. If the applicant, if the beneficiary has the assets under their control, we're in a first party supplemental needs trust. If not, it's a third party. As they said, big takeaway is that Medicaid reimbursement. Everyone's paid their fair share during their lifetime. We don't need to make any additional donations upon our passing. So to the extent that we can, it's always my job to make sure we would work with clients and counsel clients so their hard-earned money is applied for the benefit of their beneficiaries, not going back to a Medicaid reimbursement. But this was handled very well by Nancy and Kathy. And I guess just from a legal perspective, what is a supplemental needs trust? For my purposes, really a supplemental needs trust is a fully discretionary lifetime trust. What that means is our trustee has the sole and absolute discretion to make distributions or to not make distributions. This is why that role of trustee is so important. especially with supplemental needs trusts. I work with clients, and there's a concern, of course, when it's a future funded trust, it's being funded at the passing of mom and dad, typically for the benefit of a child with disabilities. So they are the caretaker for this child for their entire lifetime. It's a huge anxiety as to who is going to take over that role. So that's why it's so important to choose your trustee wisely. I think Nancy and Kathy did a fantastic job when they described really the two balancing factors. One, you need a trustee that can absolutely make sure that the supplemental needs trust is administered properly. There's no improper distributions. Tax filings are done on time, accountings are provided, and prudent investments are made. And on the other side, you need to make sure that you have someone who understands the beneficiary, knows what their needs are, is regularly meeting with them, and can make sure they can advocate and make sure that the purpose of the supplemental needs trust is fully utilized, that the beneficiary has the benefit of their government benefits that may be provided for, and using the assets of the supplemental needs trust to supplement those needs that the government's not providing. So very, very important. These plan care managers are able to meet with beneficiaries. That's the most important thing. We work with clients to make sure that to the extent they want to, they create side letters of instructions to the trustees, just to make sure that they know what the beneficiary likes, their dislikes, things that are important to them, and ways to enhance their quality of life, and things to look at when making distributions. I also like side letters because, as Nancy and Kathy were talking about, a lot of times it's the professional trustee's job to say no. So we've run situations where a trustee is administering a trust with benefit of a beneficiary. In the previous example, the beneficiary wants the Porsche. Well, the Porsche is not a prudent decision. So that supplemental needs trustee has to say no. If there is a side letter to the trustees that the trustee can share with the beneficiary and say, well, hey, mom and dad didn't want you to have a sports car. Mom and dad wanted to make sure that you were cared for properly, that you were comfortable, that you had all the therapies that were available to you, and so on. So really anything that we can do for mom and dad to put their wishes in writing, that can really be helpful for a trustee, in my experience, to lean on and say, I'm not the bad guy, I'm doing what the trust tells me to do, and I'm honoring the wishes of your parents. So communication is key. Our trusts outline permissible distributions. I made sure I put every single one here in very small type print so you can see. But essentially anything that is not being provided for by government benefits, things that can supplement, not supplant those benefits. But again, very, very important. As you can see, it's a daunting task for a layperson to be able to administer this trust, make distributions on a weekly basis. So always good to rely on the expertise of professionals. Risky or impermissible distributions. Again, you can buy what would happen if you did make a impermissible distribution. You jeopardize the benefits the beneficiary is receiving, and you risk violating the terms of the trust. So again, very important to make sure a professional fiduciary, a professional trustee is providing oversight, making distributions for permissible purposes, as to not violate the terms of the trust, or even worse, jeopardize benefits for the beneficiary. I'll just touch on this very briefly. Nancy and Kathy did a great job. Any trusts that earn income, which a supplemental needs trust will be prudently invested. It's going to generate income. Tax returns are required on an annual basis. And again, anyone gifting more than $17,000 in a calendar year to a trust is required to file a gift tax return. Common misconception, no tax is owed on either side if you gift more than $17,000 a year. It just takes away from your annual exclusion, which right now it's about $13 million. So not a big consequence for most folks, but it is important to file that informational return. Things to watch out for. I review a lot of supplemental needs trusts. When clients come in, we do a complimentary review of any estate planning documents they may have. And we make sure to take a close look at supplemental needs trusts. We're looking for things that would violate policy regarding supplemental needs trusts. One would be the beneficiary's right to revoke or amend the trust or dictate distributions. I met with a woman actually this past week. She came from out of state. She had a Connecticut attorney prepare a very robust estate plan for her that included a standalone third-party supplemental needs trust that was to be funded at her passing. So I took a look at the trust, and immediately it was very apparent that the attorney that prepared the trust did not specialize in estate planning and elder law. The trust they prepared, it was an irrevocable trust, which, as Nancy said, is a requirement for supplemental needs trusts. However, it was the wrong type of irrevocable trust. It was an irrevocable life insurance trust, which serves a completely different purpose than a supplemental needs trust would. And this irrevocable life insurance trust, in order to be valid and provide the tax benefits, there needs to be crummy rights or withdrawal rights for the beneficiaries. That gives the beneficiary the authority within a certain amount of time to take assets out of the trust after they've been deposited. So I told her, best practice, go back to this attorney, ask these questions, get him to fix this trust or prepare you a new trust, because this will not work. If the beneficiary has any rights to demand assets, any rights to withdraw assets, that's not going to work. That's not going to achieve the benefits of a supplemental needs trust. Also, an important distinction I always look at when reviewing trusts with folks: who can remove the trustee? Typically, the donor will be able to remove and replace a trustee during their lifetime. Other times, it's a court of competent jurisdiction. But as we said, that role of trustee is so important. You want to make sure that there are potential checks and balances, and if things go awry or if a change needs to be made, a trustee can be removed if necessary. In my trusts, typically, if when someone comes in to draft an estate plan, we talk about their beneficiaries. If there's any potential for a beneficiary in the future to be receiving government benefits, which is obviously a very tough determination to make, I always like to include standby supplemental needs trust provisions. So this would be for a future funded trust. So the standby supplemental needs trust provisions give the donors of the trust the authority to appoint a trustee who's able to make a determination at the time of distribution. So mom and dad create a estate planning trust for their 3 kids. Something happens to one of the beneficiaries, they become disabled, they're receiving government benefits. Mom and dad pass away before they can amend their estate plan or talk to the folks at plan and properly plan for their supplemental needs beneficiary. In this case, the standby provisions in the trust will give the trustee the authority to say, okay, wait a minute. The trust is drafted states this share should go out to the beneficiary outright free of trust. It's going to go in the palm of their hand. That's going to disrupt their benefits. They're going to be over asset. They're going to be kicked off those entitlement benefits. They'll have to spend through the inheritance and then reapply. It's going to be a mess. With a standby supplemental needs trust provision, the trust allows the trustee to say, I'm going to carve out a supplemental needs trust for the benefit of this beneficiary so that we can preserve and safeguard these assets. Also very important, all of our trusts also include provisions for a trustee to appoint a co-trustee and a professional trustee to serve along with them. We'd like to build this in for flexibility because, as Nancy and Kathy alluded to, the job of a trustee, it can be a full-time job. So a lot of times it's aunt, uncle, family friend, the CPA is appointed by mom and dad to serve as the trustee. But if it's a supplemental needs trust, especially once they get into the administration, the ongoing needs, the complexities, the tax requirements, questions regarding distributions, I get calls all the time from trustees that say, hey, I need help. I have to tap out. I have to enlist a professional because this is becoming too cumbersome. I'm concerned that I'm going to violate the terms of the trust. I'm concerned that I'm going to jeopardize the benefits for the beneficiary. Where do I go? I need help. That's why the folks at plan are so important, where they can step in, serve as a trustee or a co-trustee to make sure everything will be administered properly. So I guess if you're listening to this webinar and you're considering if a supplemental needs trust is right for you, my advice would be to speak with an estate planning attorney that specializes in estate planning and elder law. And if you're not even sure that it is going to be required, if there's the potential that it might be required in the future, when you're making your estate planning trust, make sure you have those standby supplemental needs trust provisions, because that affords your trustee the flexibility in the future that if a supplemental needs trust is required, it can be carved out for the benefit of the beneficiary. And that's all I had. Those are my slides. Happy to answer any questions. Just like the folks at Plan, we offer free consultations. If there's ever any questions, folks can call the office. We're happy to review documents at no charge. Happy to help folks as we can.
Thank you so much. I don't think we have any questions. We can see. Let's see. No. Oh, let's see. Oh, Teresa wants to know if she can have the contact for you speakers.
Yes, of course. We put that in the chat or.
Yeah, you can put it, or I don't think there's a chat function here. I'm trying to think. Do you have it on one of your slides?
I think I don't actually know, but I'll just put it. And to that question, Teresa, can the special needs trust be used as a beneficiary for insurance purposes? Yes, if the question is, can the special needs trust be the designated beneficiary to receive those insurance proceeds? Yes, that can be done. That has to be done directly with the issuer of the policy.
Perfect. And were you able to give her the contact information?
Yes, I just replied with my email.
Great. Well, thank you so much, Frederick, Kathy, and Nancy for speaking for our webinar tonight.
Thank you for having us.
My pleasure.
Have a nice night.
You too.
Thank you, everybody. Have a nice night.
Thank you so much. Have a great evening. Bye-bye.